Hi there, welcome to the next episode of the Advocates Lounge. My name, for anyone who doesn't know, is Adam Mugliston. I'm an employment practitioner at Deer Street. I want to speak to you today about day one employment rights, particularly in the context of flexible working and unfair dismissal. The Employment Rights Bill was published on the 10th of October 2024, and among its enormous scope, there are two particular issues I wanted to discuss today because they're causing concern among employers and some confusion among employees, and they picked up rather a lot of attention in the press. In particular, these relate to day one rights in respect of unfair dismissal and changes to rules relating to flexible working. There had been numerous press releases and indications from ministers that there would be a complete sea change in respect of flexible working. However, under the 2024 bill, it actually doesn't appear that much is changing at all of any significance. It's worth taking a step back and reflecting on the fact that changes already came into place on the 6th of April 2024. In particular, there was no longer a requirement that employees set out a business case, as it were, for why the flexible working request should be granted. The changes that came into place from the 6th of April 2024 included fundamentally making this a right from day one. There was no longer a 26-week continuous employment qualifying period before an application for flexible working could be made by an employee. It also obliged employers to consult with an employee when considering a request, removed the need for the employee to set out a business case, effectively explaining how the flexible request could be accommodated by the business needs. Further to that, it reduced the time period in which requests had to be dealt with from 3 months to 2 months. What it didn't change are the 8 reasons that an employer can give for rejecting a request. So practitioners will be aware that the reasons that can be given for rejecting a request include the burden of additional costs, the detrimental effect on the ability to meet customer demand, or an inability to reorganise work among existing staff. There's also the inability to recruit additional staff, detrimental impact on quality or performance, or indeed a lack of sufficient work during those periods that the employee does want to work. This was supplemented by a new revised ACAS code relating to flexible working requests. It talked about a change in mindset, but in a practical sense, had additional matters added to the good practice guide, in particular, the right for employees to be accompanied at meetings by a colleague or representative, the suggestion that employers should provide additional information explaining their reasons to the employee if they were deciding to reject an application, and also providing for appeals to be dealt with by a separate manager, effectively providing a fresh pair of eyes. If we take a look at what the Employment Rights Bill 2024 has to say about flexible working, we might be rather surprised in light of numerous press releases and interviews in which ministers were insisting that there would be a complete change to a default position in which flexible working would be the norm. Under the new bill, there's very little change in reality other than a requirement that employers give reasons. Now, they're required to give an explanation as to why they consider it reasonable to reject the application on the grounds stated. What doesn't change at all, however, is the grounds that they can reject an application on. There's also no change in emphasis by, for example, increasing the awards for breaching this. There's still the same entitlement to up to 13 weeks' pay in respect of that. And what there certainly isn't is what was being mooted in the press, which was an automatic entitlement to a 4-day week. There's absolutely nothing mentioning that at all. So what do we take from this going forwards? The biggest issue for employers will remain that this is an entitlement from day one. There's going to be a particular temptation to fall into feeling ambushed if very shortly after recruiting a new employee, they make an application for flexible working. Employers may well be wondering why that wasn't addressed within the recruitment process. But my advice is not to fall into that trap. There might be perfectly valid reasons why an employee doesn't, before securing the appointment to the role, mention the requirement or desire they have for flexible working. And the reality is the focus of an employer's decision needs to be on the merits of the application and whether or not it can be accommodated, or whether or not the reasons for rejecting it fall into the grounds provided within the relevant legislation. Another issue for employers is likely to be querying the extent to which they actually have an opportunity to assess a new employee's capabilities or how efficient they're likely to be, either working in, for example, an office or from home or at different hours to the rest of the workforce. They may think they've got no basis of comparison if they've not been working for them for long enough to form any real view about this. But in those circumstances, it does seem to me that an employer can, as part of the reasons for rejecting an application, rely on the need for a normal probationary period to assess performance, as it were, before a request can be granted. Now, in those circumstances, the best thing to do might be to agree with the employee to extend the time period of 2 months in which the application has to be determined. That does two things. It gives the employer the protection of knowing they're not falling foul of that time limit. Also, from the employee's perspective, ensures that they're not effectively using up one of the two opportunities they get within any 12-month period to make an application for flexible working. So any agreements to extend that period need to be agreed mutually and, importantly, set out in writing so there's no dispute about that going forwards. Fundamentally, the real issue for employers is the amount of time it takes to consider applications, consult by meeting the employee in order to discuss these matters, responding in writing to the application, and thereafter potentially providing for an appeal. Now, of course, as it stands at present, there's no strict legal obligation to provide an appeal in respect of a decision to refuse an application. However, it's good practice as referred to in the ACAS guide, and one might think, if there's been an opportunity for a fresh pair of eyes to consider an application, first of all, it might make the chances of future litigation less likely, because an employee will know that at least two separate individuals have looked at the application and both decided to reject it. Or it may even mean that that fresh pair of eyes is able to think of other means of accommodating the request that aren't quite that were actually being sought by the employee, but also aren't as firm as the reasons for rejection by the employer. I would also advise that although it's not a strict legal obligation and will not become so unless and until the bill takes effect, that employers do provide explanations in writing amounting to reasons why they can't accommodate the request. So although that's likely to be a time-consuming process, there's a number of advantages to that. First of all, again, one would hope that if a well-reasoned, well-thought-out explanation is provided to the employee rather than just a bare refusal, they might be less likely to bring that as a complaint before an employment tribunal. Secondly, it means that there will be, in the event of a tribunal claim, consistency, because there's no reason why an employer, if they've properly thought about the request and given it due consideration, but set out in writing the reasons for rejecting it, wouldn't simply be able to rely on that very same logic in response to an employment tribunal claim, and indeed evidence before a tribunal were it to come to that. The other reason to provide the explanations for rejecting an application in writing, despite there not being a strict legal obligation to do so as yet, is that it is included within the good practice guidance as suggested by ACAS. It's always worth bearing in mind that the test the tribunal will apply, if there's a complaint to a tribunal in respect of flexible working, is whether or not the employer reasonably considered the request. So it can only assist an employer in advancing arguments that it reasonably considered it, to be able to demonstrate that it provided detailed explanations as to the reasons for the rejection back at the time it was considered. But fundamentally, it's always worth employers bearing in mind that there's ample scope within the reasons permitted by statute to reject these requests if there's a genuine reason for not being able to accommodate them. If you can't articulate reasons within a document provided to the employee, explaining to them in clear terms why it is that the application is being rejected, then it does call into question whether or not those are valid reasons in the first place. The part of the bill that's really been grabbing the headlines is in respect of protection from unfair dismissal from day one. So removing the qualifying period for employees to bring complaints in respect of unfair dismissal. Now, practitioners, of course, will be well aware that there's currently a 2-year qualifying period, and that was increased from 1 year back in 2012. The potential implications of this on the face of it are huge. The government's estimated that this potentially brings some 9 million employees within the scope of that protection, who otherwise would have fallen outside of it. Now, that is about, or certainly approaching, a third of the workforce. There's been some suggestions, again reported in the press, that this is potentially going to be increasing employment tribunal claims by some 15%, notwithstanding the fact that there doesn't, at this stage, appear to be any corresponding commitments to fund any additional work in respect of a system that's already, certainly in the regions I practice in, struggling. What the bill does is use primary legislation to completely remove that qualifying period. Now, that's of particular significance because, of course, if any future government looking at this wants to effectively overturn this, it would have to do so with further primary legislation. Statutory implements seemingly wouldn't be enough to reintroduce, as it were, the qualifying period as it had previously existed. However, it's not as simple as rights to protection from unfair dismissal applying as they currently do to everybody from day one. What's clear from the bill is that matters are going to revolve around what's referred to as a statutory probationary period. Now, that statutory period of employment, or initial period of employment as it's referred to in the bill, is what all of these significant changes are going to centre around. But despite this being precisely the detail that practitioners and employers are keen to understand, the bill itself reads as being rather rushed in this respect. The government had committed some time ago to publishing the bill within the first 100 days of being elected. And what they seem to have done in missing out all of the relevant detail is leave the crucial blanks, as it were, to secondary legislation, the form of which is presently entirely unclear. What is clear from the bill is that the intention is that during that statutory probationary period, it'll be easier for employers to dismiss. Now, there's 3 methods proposed effectively of achieving that. It's not clear exactly what form these will take. It's not clear if all 3 are going to be brought into effect. Now, the first of those is to modify the test of fairness under the existing legislation. So, effectively amending Section 98(4) of the Employment Rights Act 1996. What format that would take, however, again, is really open to question, but also, more significantly, what difference this is really likely to make. The wording of the Act could be changed to make express reference to the need to have regard to the fact that an employee is still within a probationary period. But of course, given how the test is already worded, one really does question what practical difference that's going to make. The current test already requires a tribunal to consider the reasonableness of an employer considering capability, for example, as being a sufficient reason for dismissal. It also requires the tribunal to have regard to equity and the substantial merits of the case. So what would it really add when presumably the fact that an employee is in a probationary period is already something that the tribunal would readily have regard to when assessing the fairness of a dismissal? The second method that the bill proposes to make it easier to dismiss within a probationary period is effectively to set a presumption that a dismissal be fair, presumably unless the contrary is proven by the employee. Again, to date, how such provisions will be worded is entirely unclear. They may effectively deem a dismissal to be fair unless, for example, the reason given could be demonstrated by the employee as being a perverse one. But again, it calls into question what difference that really makes to the current law in respect of unfair dismissal. In particular, there's already a band or range of reasonable responses test that the tribunal will apply. Is perversity really extending the scope of that beyond the test that the tribunal already has to have regard to? I suspect the answer to that is no. The third and probably most intriguing thing that the bill envisages is a probationary dismissal procedure. Now, again, entirely unclear what that will actually involve, but fundamentally, it would seem the intention is to set particular hoops that an employer will have to jump through in order to ensure that the dismissal of an employee within that probationary period is fair. The concern from an employee's perspective is that it looks as though this is going to be focused on procedure rather than the substance of the decision justifying the dismissal itself. Presumably, particular steps will have to be taken by an employee in order to dismiss during that period. Those steps may involve nothing more than raising in advance with an employee what the particular concern is so that the employee can respond to that. It's not clear if, for example, there would still be an entitlement to appeal that decision, or whether or not, insofar as it relates to capability, the employer is going to be obliged to set measurable targets that can be objectively assessed at some future meeting. It's entirely unclear. So what we don't know is whether this is actually going to give employees within that probationary period a genuine chance to improve their performance, or whether it's simply a box-ticking exercise in terms of procedure that has to be followed from an employer's perspective. Within a couple of weeks of the bill being published, on the 21st of October, the government published fact sheets, presumably intended to flesh out some of the detail on how protection from unfair dismissal from day one was going to operate in practice. However, again, considerable amount of crucial information that's still not addressed in those. It does, interestingly, confirm that the government's proposing that this statutory probationary period be for a period of 9 months. Now, that's significantly longer than the 6-month period that had initially been suggested by the government. You may think that's indicative of the government reeling back to some extent from their initial proposals because of pushback from business. And that may give cause for concern from an employee's perspective as to how much some of these rights are likely to be watered down following consultation going forwards. The other thing that the fact sheet makes clear is that consultation will be starting next year and that there will be no changes introducing day one protections in this respect until at the earliest autumn 2026. So we know that employers are going to have plenty of notice of these changes before they take effect. In attempting to provide more detail as to what's envisaged, the fact sheet suggests a lighter touch and less onerous process will apply to dismiss someone who, as they put it, is not right for the job. But what on earth that means is beyond me. This yet again sounds to me as if it's the procedure rather than the substance of the decision to dismiss that's going to be the focus of the new rules that relate to that probationary period. One interesting point that the fact sheet does say is that they'll consider changes to compensatory awards applicable for employees dismissed within that probationary period. Now, presumably, basic awards wouldn't be applicable anyway, because nobody would have had on the current formula for calculating those at least 2 years' service if they're within a 9-month probationary period. But what this does raise is the question as to whether or not employees can claim unfair dismissal if made redundant in a period of less than 2 years of commencement of their employment. Because, of course, if they can, there still wouldn't be any entitlement to a basic award. However, the compensatory award would be applicable, which means that any changes they might make to the compensatory award within the probationary period are going to be of particular interest. So what can we take from this going forward? Well, unfortunately, the answer, given the lack of detail in the bill, is not much at present. Save that, it's quite clear that probationary periods are going to become front and centre when these changes come into effect. So employers will be well advised to take a look at policies they have in respect of assessing capability during and at the end of probationary periods, not letting unsatisfactory performance or capability slide beyond the set period, rather addressing concerns as and when they arise, setting specific dates or time frames within the policy to assess, by reference to objective, measurable criteria, the extent to which somebody is performing adequately within the job, and making sure that prompt action is taken as and when it's needed to address that. Of course, employers currently engaged in recruitment processes will be well aware of the fact that by the time these changes take effect, we'll already be 2 years on from now. So those employees that they're currently recruiting would have full protection even under the existing legislation in any event by that point. Personally, what I'm particularly curious about is whether or not these changes, once they do take effect, are actually going to lead to claims being rather more straightforward than we're often used to seeing. Practitioners may be well aware of a fairly inevitable trend when there's a 2-year qualifying period for claimants who don't have that 2 years continuous service to dress claims for unfair dismissal up as relating to, for example, public interest disclosures or other grounds on which they wouldn't need the 2-year qualifying period. So one might hope that going forward, the kind of contortions we're used to seeing to fit claims into the existing statutory framework in order for tribunals to be able to hear them should disappear to some extent, and claimants can actually focus on the real things that matter to them, which typically is whether or not it was fair to dismiss them, not wider issues that they're obliged to bring into claims in order to get over the 2-year hurdle. But as and when we get more detail about these changes, we look forward to producing further podcasts and updating you in respect of those. Our intention will be to provide similar podcasts in future, talking about, in fairly broad terms, other matters that are covered by the bill in question. But until then, thank you very much for listening. We hope you found this helpful or at least interesting. Thank you very much.